suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Yes, indeed. It is that time of the week. Possibly you're confused. Apparently I opened the program an hour and a half ago by saying it was Thursday, which I apologise for and had not realised that I'd done. I did get the date right, so that's maybe why I haven't had a flood of complaints. But of course it's Tuesday. And because it's Tuesday, David Whiting has joined us. Melbourne solicitor, the man who can answer all your legal questions. And there are lines free, 1300 222 774. Or you can text on 0437 774 774. Take the opportunity while there are some lines and give David a call with all your legal queries. Good morning, David Whiting.
Good morning.
Noxious weeds.
A story out of the UK. My house block is basically paved and I'm not very good in the garden, but there is something called a...
Concrete?
Paving stones, do you mind? There's something called Japanese knotweed. And
even though it's not weed, it is a weed?
Oh, it is a weed, yes. And there have been a couple of cases in the UK that the seller of a property needs to declare whether there is any of this weed on the seller's property. Failure to do so can lead to a claim in damages. The Court of Appeal last week had to decide whether a local authority, a council, was responsible for knotweed that escaped from their cycle path into someone else's property. And the original judge said, no, it's not something known to man. The Court of Appeal disagreed. So it's a case that has a value of $10,000 and a legal bill of $600,000.
Wow.
Yes.
That should have just gone to arbitration, shouldn't it?
Well, no, the council said, don't look at me. And the valuation dropped by £4,900 as a consequence of the infestation, which had been cleaned up, but there was a residual issue. And the estimated cost to run the argument all the way through, £300,000, so $600,000. Just wow.
Yeah.
I don't know what the law is here. I don't.
No.
I profess to know nothing about the weed here. Glad I don't.
You did have homework, didn't you?
I did. The first homework was over a closed coastal walking path at Apollo Bay. And what was truly fascinating was the number of emails I got during the week with people with an opinion. And there was one gentleman who sent me a 47-page report of things that I needed to take into account in considering the view.
Which you read?
Lots of it was pictures.
That's good. That made
but
it
it
easier.
included the lease that the golf course has over the land adjacent to the bay. And what happened is the authority it's a relatively newly appointed authority to take over the coastal property near the Great Ocean Road, and they have closed a path. And not only have they closed the path, they said, and we are not going to reopen it. And they say there were some issues in relation to risk with golf balls, there are issues in relation to land slippage, and then there are some issues that we can't tell you about. And the answer to Tim from last week, who initiated the call, was they are within their authority to close the path, and they didn't need to do it without consultation. But I do think there ought to be a degree of consultation about their failure to reconsider the decision. So you could close it for safety reasons, which is one of the reasons. So from that point of view, entirely valid. But
be open to discussion.
You'd be open to discussion as to, not necessarily to be persuaded, but open as to discussion as to the other. Otherwise, complain to the minister. So the minister has empowered the authority to look after this parcel of land. If you don't think it's proper, the way they're dealing with it, you could make a Freedom of Information application to the authority to get the records that led them to the decision. And then if you're still not satisfied, you could complain to the minister.
So a couple of years down the track, Tim, you might get a resolution to that,
yes.
But there's a pathway. And there was another question that we had, and that was why, when you do a roadside breath test, won't they tell you what you've blown?
Well, first of all, they're not obliged to, because it's not the basis of a charge. unless it's failed to blow, and in which case it's not really relevant what the reading is. And that, in short, is the reason. I've also thought that if it showed that you were 0.02 or 0.03, then I would be suggesting that one might say, I can have another couple of drinks and I'll be fine. I would have thought from a social policing point of view, I would be discouraging that.
But there's no rules around it. Is that what you found?
Well, there might be an internal police rule. There's no law around it.
Right.
And it's if you're going to get charged for the 0.05, it's on the van. It's on the basis of the reading on the van that you go to.
The formal.
Yes. The proper machine.
Yes.
Yes.
You take it out of your car and put into the van.
Do you know they record the outcome of each machine against each police officer? So did you let anybody go who was?
Oh.
It's interesting. So if you're
Do you think there's a bonus system?
No, I don't. I don't. I think it's a disincentive to let somebody go.
Yes. I don't know that they really need...
A
Do they
disincentive?
need? No, I wouldn't have thought so.
No, I wouldn't have thought so, no.
Heather in Colac. Hi, Heather.
Hello. Yep. Hi, Dave and Nellie. Look, our son has a hobby farm, 16 acres. His neighbour is a sheep farmer and is now wanting to sell the sheep and put cattle on his property, which will cost, he's needing new fencing, so that'll cost around $40,000. Does our son have to pay his share of the fencing?
When you have different uses, such as you've got, the person who wants more pays more. So if your son's neighbour requires a higher standard of fencing, and the current fencing is perfectly adequate for your son, the uplift is the responsibility of your neighbour.
Right, okay. So he just needs to go to the neighbour and give him that information.
Yeah, if you look, there's a provision in the Retail Leases, in the Fences Act that talks about it. So you can get that if you search the Fences Act, you'll get a copy, and you can look and see what the rules are in relation to competing neighbours. But if you want more, so for example, if I was building a house and wanted a paling fence, the paling fence would be at my cost, not at your son's.
Right.
Okay.
Terrific.
Thank you.
Thanks, Heather. Junta in Phillip Island. Hello, Junta.
Oh, good morning. How are you? My daughter, who is 41, and my grandson were driving to school in 2021. During a storm, wild winds, and a tree branch fell on the top of their car, and it wrote the car off. And I found out that Regional Roads Victoria were responsible.
Yes.
So I wrote to them, and they took nearly 12 months to respond.
Yes.
And they said they couldn't do anything about it. So what I want to know is whether we can sue anyone. Because the car was a write-off. She had to get a new car, which was $25,000.
Can I ask you, Ajunta?
Yeah.
Are you suggesting that there can't be trees next to the road?
No, I'm not.
No, see, that's the difficulty that you've got, is that there's a tree. I do think that if they had looked at the trees on that stretch of the road and this tree was ready to drop a branch, then I would suggest you might have a claim against them, but they're not responsible for every individual tree and what might or might not fall from it.
So this
and you did say it was a particularly bad storm.
Yeah, and this stretch of road is notorious because what they do is they cut the trees back for the power lines, which creates a wind tunnel, and all the trees lean over the road.
Junta, did you have insurance? Did insurance cover it?
No, she didn't.
Oh,
she didn't.
Okay. Junta, you would need to see, you might get reports as to what they did, so you can ask them for what maintenance they'd done on the road. Then if you can establish that there was a wind tunnel caused by the trimming, then yes, you would have some form of claim against them to the extent that it made the situation worse and made it more likely. But if it was me and I hadn't inspected the tree recently and worked out that yes, a branch would fall soon but didn't do anything about it, you couldn't have a go at me. There's a thing called the Road Management Act, And if you have a look at that, that will give you some idea of the protection that we provide to road management authorities.
Good luck, Junta. Amanda in Mont Albert. Hi, Amanda.
Yes.
Yes,
Hello.
You're on the air. Hello.
Oh, sorry. Good morning. I'm just ringing about real estate agents. And we're just having a number of issues with the property management, including like loss of keys, no inspections, but also there was
So
a lot
are
of
you the landlord or the tenant, Amanda?
I'm the landlord.
Yes.
So there was a lot of damage from our previous tenants, holes in walls and stains and rubbish and everything. Anyway, they did some quotes to get this all fixed up and gave us a price and told us what was being done. And then through the work order, the people doing it didn't actually fulfil that. So we went back to them and said, look, this has not all been done. And they are sort of saying, no, we refuse to take responsibility for it. And they're not.
But are they not even pursuing the tradesperson who came along and didn't do what they were required to do?
No, well, they've actually given them my personal details. This is how far it's gone. And that they contacted me directly, which I said I've never, asked them to do that.
Sounds to me like you need a new property manager, Amanda.
Yes.
Yes, no, certainly do.
Yes.
I'm just wondering in terms of, what can we do in terms of, lodge a complaint or to...
Well, what's the complaint?
That they haven't managed our property correctly and they've said that they'd get
So
work
what you're
done.
really looking then for, Amanda, or looking at, is some kind of complaint to VCAT suggesting that there ought to be an adjustment to the management fee for their failure to act as you think they should have acted. But I'm just simply wondering whether it's going to be worth your while to run the argument.
Oh, okay.
Right. So if you think about it, they've been a property manager for whatever period, and what we're really talking about is an inadequacy during a relatively short period.
Mm-hmm.
So if let's say they've been managing the property for 24 months, and in month 25 they mess up, you're really only going to get back your management fees at best for month 25.
Right.
Right.
But if they've done, since the tenants have been there for 7 months, they've done no inspections and then...
How many inspections would you expect in a 7-month period?
Oh, well, at least one when the tenants move in.
But they would do the inspection before they move in because that's required for the condition report for the tenant moving in.
Yes.
No, you wouldn't go a couple of weeks later and make sure they've put everything away properly.
Oh, no, 3 months later.
Is that an expectation, is it?
Yes, I think it is within the...
It's not every 3 months, I don't think, is it?
No.
For a new tenant.
Oh, okay. All right. And can you tell me, did that problem exist 3 months into the tenancy? Don't know. But that's part of your case to quantify the amount that you should get back from the property agent.
Amanda, thank you for your call. David in Cheltenham. Hello, David.
Oh, hello. I'm a parent of an adult son who has mental health issues, and he doesn't agree that he does have. Now, I've been for quite some time looking after him, and I've come to the point where the government or the state health department, in fact, won't do anything, and I'm contemplating guardianship or power of attorney. How is that possible? What do I need to do? What hurdles do I have?
I'm sorry. There are no orders affecting your son at the moment?
No.
Okay. So you apply to VCAT and you want to work out what role you want in relation to your son's care. You may come along and say, I'm happy to be the person who makes the decision about where he lives and what he does on a daily basis, and that would be guardianship. But if you want to manage his financial resources, that would be administration. But you're going to need to start with a medical report which says that he needs someone to make decisions in relation to those kinds of things for him.
And that medical report would have to be upon assessment of himself, yes?
Yes. There's no...
But if he's not
the
willing...
difficulty you've got is that... Oh, sorry, does he have a treating doctor?
Yes and no, not really.
Well, but he does attend a doctor from time to time.
Not yes, but even then, I'm not even aware of that, Doctor. And it is
the presumption in the legislation is that your son is competent. So you're going to have to persuade the tribunal to get a medical assessment or order one for your son.
Mm-hmm.
That's going to be difficult because the presumption in the legislation is competency.
And so my direct application at VCAT is which?
You're making an application for guardianship and administration, and you're going to have to persuade the VCAT member that based on everything that you tell him that there ought to be a medical assessment undertaken of your son.
Sure, thank you.
Pleasure.
Thank you, David, for your call. Kay in Footscray. Hi, Kay.
Hi, David and Ellie. My issue is my husband and I mow our neighbours' very large lawns. Now, our neighbours are tenants and the landlord doesn't have insurance on the house or the property. And my neighbour has contents insurance. Now, my question is, if my husband and I are mowing and a hard object flicked up and hit somebody, would I be liable for their injury?
Yeah, well, it depends. If it was your husband who was doing the mowing, he'd be liable. If it was you that were doing the mowing, it would be you that would be liable.
Right. So if the landlord had insurance, then
you would need to know what the terms of the policy. And remember that the neighbour, the owner of the property next door, hasn't hired you.
Yes, that's right.
Right? So if I was engaging your services, then I may or may not be liable, but I've engaged you as an independent contractor. You've got your own mower, you bring your own broom to clean up. I would have come along and said, Kay, you're on your own.
There's no sort of good Samaritan if you're doing it as a favour?
Well, is mowing the lawn the same as a need?
Oh, yes, from a snake perspective.
Somebody who...
In Footscray, probably not.
No, that's true. Kay,
it's a large property with a lot of trees, and it's been left
to rack and ruin. Yes.
Yeah.
It's still my view would be your neighbour, the property owner, doesn't owe you any liability, any responsibility. Your neighbour, the tenant, might, but will have no resources, and so at this stage you're on your own.
Sorry about that, Kay. Steve in Donnybrook. Hi, Steve.
Hi, how are you both?
Well, thank you.
Very good. Look, just a quick one, David. I'm having severe issues with a builder. I will not mention the firm, but they're a known
Thank
company.
you very much. Yes.
He's late on delivery of my house by... Well, it should have been finished in October 2021.
Yep.
And we're still having issues with, work quality primarily, and we're stagnant at the moment. So I initiated a mediation through the relevant body.
The domestic building, the conciliation thing.
Yeah.
Yeah, and then because it's a domestic building dispute, off you go to VCAT. You have no choice.
Now, this comes to my question. The builder says it's going to take at least a year and a half to 2 years to get the VCAT, because I've threatened him with VCAT already.
Yes.
And he's acknowledged that with his stance on everything, which he's just belligerent,
yes,
that we wouldn't come to any agreement in VCAT anyway. And I've got that in an email.
Yes.
I'm just wondering if I could seek legal advice and go straight to the magistrate's court with it.
No is the answer. The building disputes go to VCAT. They have been given the jurisdiction.
Yeah.
No choice.
I've had dealings with VCAT before on other issues and won at VCAT, but a win's a win, but no one pays. But anyway, all right, so
that's
it's going to be a long, drawn-out process.
It is indeed.
Sorry, Steve, to not be able to be the bearer of better news. Alyssa in... Oh, don't know what happened there. Alyssa in Bayswater. Good morning. Alyssa.
a retirement village.
Oh, sorry, I just cut you, Alyssa. I just cut the top off you there. So you've put your mother into a retirement village,
Retirement
is that right?
village,
Mm-hmm.
yes. And I'd like to know from David, is a deposit classed as an equity? We've had to transfer her from service department to the care centre in the same facility. They requested it. We'd only paid the deposit, but they said the deposit was not classed as an equity. So we had to pay another $36,000 on top of the $650,000 for the bond.
The RAD, the resident accommodation deposit, right?
Yes.
So your mother was going to be buying a service department. There's a couple of ways they fund service departments. Was it a loan, or was she buying?
She was buying it.
Right.
Oh, yes.
Right. So if it was,
it's the loan. Yes.
But when does the loan come back?
When she deceases.
No, that's the RAD.
Oh, okay. So we were told that if you move from the independent to the service to the care facility, the equity in it transfers to each of the different sectors. So we'd put her in.
She's paid a deposit.
Yes.
So she's paid a deposit for a service department in a retirement village type place.
Yes.
And then what's happened is that she's not well enough to stay there.
That's correct.
She's moved to the aged care facility element. She's paid a bond of $600,000.
Yes.
And you can't get back the deposit she paid on the other one.
No, that's correct.
Why not?
They said that the deposit isn't classed as an equity.
My difficulty would be if it stays there as part of her residence obligation, then it ought to be considered by Centrelink, for example, to be as if it was part of her right of residence in the property.
Yes.
On the other hand, if it's a loan and the loan's not repayable till she died, then yes, it's properly classed as one of her assets. But I do think it's a question of looking carefully at the documents and see what it is.
Yes, I have had a solicitor to look at it, and she can't work it out.
Well, I'd be looking at the document relating to the entry into the service department and work out what the requirements in that are for repayment.
Okay.
Could be something in that.
Gosh, it's complicated, isn't it?
Life is, really.
The whole aged care system is very complicated. And I've got a text here from Joan on the Mornington Peninsula who says, been renting for 30 years, inspections usually the first 3 months, then 6 monthly. Gosh, I've rented for a very long time and I don't reckon I've ever had a 3-month inspection.
No, we rented for a while. I haven't had a 3-month inspection. My frustration with inspections are they tend to think an 8-hour block is enough appointment time. That's my frustration.
Yes, we'll just stay home for you.
Yes.
Yeah, it's like the washing machine repairman, isn't it?
Or Telstra or any of those people.
Yes, indeed. David Whiting, thank you. We will see you next week. And you have been given a homework-free week.
Oh, thank you.
It's a bit lucky, isn't it?